Every day in the USA, people find themselves in court.
22-39815 is now called the State of Texas versus Claudia Marks. Is that you?
Yeah.
Claudia Marks with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
And first of all, the request of defense, the defendant was evaluated by Dr. Ed Rapon for competency purposes, and in a letter dated September 3rd, 2024, the defendant was deemed competent to stand trial and is not in need of inpatient psychiatric treatment intervention. All right. In summary, this indictment alleges that on or about January 6, 2022 in Jefferson County, Texas, you've committed the first-degree felony of arson. Do you understand what you are charged with? Was it an apartment or in Nederland?
Yes, sir.
Yes. If convicted of a first-degree felony, ma'am, you face a term of life in prison or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range that is applicable for this charge? An agreement's been reached where you would be pleading guilty. What's the restitution on this?
It's the only, there has to be some restitution, and the only dollar figure I've been able to find in the file reflects a loss value of $20,000. According to this, if I may, Judge, according to the reports, they had to use 73 gallons worth of water to extinguish 3 active fires that were ongoing. So I know that there's restitution. My best guess is going to be that amount based on the report.
There were several points of origin of the fire here at this apartment. 2 ignition points on a bookcase near the front window, another under a chair and next to some plastic storage containers near the dining and kitchen area. Another ignition point in the living room near the wall on the back side of the kitchen. Another ignition point in the bathroom sink next to a bottle of rubbing alcohol. The final ignition point on the bed in the bedroom at the head of the bed. 6 different points of origin of this fire. I don't know, depends on how fast they got there.
Yes, sir.
6 points can do a lot of damage.
The apartment was supposed to be engulfed with flames at that time.
Who is the owner of the building? Do we know? It doesn't show.
The manager is Kimberly Kumar that is mentioned in the indictment.
I see that, but they generally aren't the owner, but I guess they.
I've given the name of the apartment complex to the probation department, Judge. And I'll check my form trial.
Okay, the agreement here would be that you would be placed on deferred, or you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, order to pay restitution, which is unknown at this time, but it may be in the amount of $20,000 or even greater, to be determined by a post-sentencing report. And it will go to a Kimberly, Kumar.
Yes, sir. That's the
Who's
manager.
the manager on behalf of the owner, to be determined of the apartment complex, to be determined upon the post-sentencing report by the probation office. Is that the understanding of the parties, including the defendant? If I follow this agreement, you have no right of appeal of your case. Do you understand, ma'am? How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily, that is, on your own free will, and because you are guilty? How long have you been in jail now? A long time?
A little over a month. She was on bond and I think they revoked her, the bondsman revoked her bond and she was rearrested a little over a month ago.
Have you lived in Jefferson County your whole life? Can you pull her up, please?
Ag assault from 1990.
An aggravated assault in 1990.
Received deferred probation and she completed it.
Okay, that was deferred probation, so that was dismissed later.
All this.
So you don't have a conviction. I'm going to find that there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, but I am going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. And again, restitution must be owed in a manner to be determined to the manager, owner of this apartment complex. And there will be other terms and conditions of probation which are normal and customary for this type of offense. Make sure you follow this. If you fail, your probation can be revoked. You can be found guilty. Then you can be sentenced up to life imprisonment. Do you understand the importance of following these rules? Let me ask you, your disability, what is your situation now? Well, you're disabled, right? You're in a wheelchair right now. What's the disability? Your back. Okay. Are you able to ambulate, walk? Are you able to walk? You have to have something to walk with, like a. Are you getting, are you planning some type of procedure for your back, or you're just gonna live with it?
Well, I already have something in my back, and you want to put another machine in my back. Because this is not working right anymore.
Sounds like
More back issues. All right. Make sure you follow the terms and conditions of probation. And where are you going to live now?
Feel like, I'm at my winter apartment.
She has her own apartment. Her sister is here.
Okay, it's a different place from the place that
Yes.
you're charged with burning down, right? It's a different apartment. Okay, please see the probation office. Thank you. Dante Powell.
Ready, he's in custody as well.
What are we gonna do today?
It's a plea, one is.
Wait, what's a motion?
One's a motion to revoke and the other is a new case. It's all related.
What are we doing?
I can give you a summary. On the motion to revoke, we've submitted an agreement to the court for a continuum on probation with 180 days in jail as a sanction. And on the new case, 2 years probated for 5 years.
It's based on the new case, Your Honor. What happened? He got out of jail, went to a guard shack right there, and I believe he tried to get in there for the air condition. There was a couple items that were just sitting outside, like an umbrella and the bucket or a chair, but then they found him just laying right there outside of there, out of the guard shack, but he was not allowed to enter into there.
And it was the same day he was released from jail. He just released from jail and made it to the guard shack before the street.
Sir.
Sir, she needs to get your fingerprint.
Oh, well, how much time does he have? Accrued, please.
I think he's been in jail since this occurred, which was June 15th. Does that sound right? Yes, sir.
Judge's time credit on the NPRP is 350 days. On the new case, it's 46 days.
All right, we're taking. Probation office was kind
Maybe,
enough.
maybe we have a minute so I can discuss that with him, Joe.
This is, you want to look at the.
No, sir.
The sentence report, and it's what we talked,
Yes.
what we just talked about. Thank you, man. Y'all let me know on that, and I'm just gonna hold Mr. Powell, but I'm gonna reject that deal, see if y'all can work something out instead. Okay, James Franklin. We'll go to James. Yeah.
I can change it on the text.
Yeah. Oh, hold on. Let's go back on Mr. Powell's cases.
Yes,
Two cases.
yes, sir. I can change it. on the
And
tablet.
in 20-34566, the older case, there is a motion to revoke unadjudicated probation. And you were Dante Ramon Powell.
Yes, sir.
Raise your right hand. You solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your hand. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary?
Yes, sir.
In summary, this states that on October 2020, in this court, that you were placed on 10 years deferred or unadjudicated probation for harassment of a public servant. Is that true?
Yes, sir.
Allegation number 2 states that you committed the offense of burglary of a building on or about June 15th, 2024, which is represented in this new indictment of state jail felony. Is that true and correct?
Yes, sir.
Are you pleading true and correct to this?
Yes, sir.
Hold on. Voluntarily and because it is true.
Yes, sir.
Do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Agreement has been reached that your probation would be revoked. You would be found guilty and sentenced to 2 years in prison. Is that your understanding of the agreement in
Yes,
this
sir.
case?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
Cause number 24-CR1690. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about June 15th, 2024 in Jefferson County, Texas, you committed the state jail felony of burglary of a building. You understand what you're charged with.
Yes, sir.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 180 days in the state jail. Is that your understanding, to run concurrently with the motion to revoke probation?
Yes, sir.
Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
And how do you plead to this, guilty or not guilty?
Yes, sir.
Are you pleading guilty to the state jail felony of burglary of a building
Yes, sir.
voluntarily and because it is true as it is alleged?
Yes, yes, sir.
Oh, no, I'm going to follow these agreements. First of all, in the older case 23-4566, I'm going to find that this motion to revoke unadjudicated probation shall be granted as you have pleaded true voluntarily, knowingly, intelligently to committing the offense of burglary of a building on or about June 15th, 2024 in Jefferson County, Texas, which is allegation number 2, and which is represented in this new indictment in 24-CR1690. Your probation earlier deferred or unadjudicated probation is hereby revoked in that case. You are hereby found guilty. And in each of these cases, I find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas and pleas are true here in the motion to revoke probation in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in 23-4566 and as well in this new case 24-CR1690 based on State's Exhibit 1 where you have entered your pleas and certified under oath that these allegations are true and correct in each of these cases. I'm finding you guilty as well in this new state jail felony burglary of a building in 1690. You are hereby sentenced to confinement in the state jail for 180 days in that case. And in 34566, your probation has been revoked. You are now found guilty. You have been sentenced to 2 years in state prison. These cases shall run concurrently. To given credit for time you have served in accordance with these cases. Do you understand what has happened today, sir?
Yes, sir.
All right, that is all.
Thank you.
Cody Wallace,
Yes, Judge.
2 cases, correct?
Yes, Judge.
Thank you very much. You're Cody Lee Wallace. All right. We have 2 cases, 18-30240 and 19-31510. These are both motions to revoke probation. I'll look at this for a second here. So on one of these, 30240, the robbery, you were placed on probation January 7th of 2019. Then about 2 months later, you were indicted on this state jail felony of illegal possession of methamphetamine 31510. But that crime was committed May 10th of 2018 before you were placed on probation in that first case. So what we did was we placed you on probation in each of these cases. There's no way. What? There's no, okay. There's no really any rational reason that you should have 8 violations in one case and 7 in another. 1 is bad enough, right? Any violation is revocable if it's proven by a preponderance. So here we are. Committing crimes in another county. And failing to report, we courtesy supervised you in Harris County at your request, and then here we are. So how long was he out of touch, absconding from Harris County?
It looks like it's, and if you refer back to the hearing dated March 1st, the March 1st of
Of what year?
2024
Okay.
was, actually a compiled of 2 different prior events. Mr. Wallace actually had been returned from Harris County when, we did lose track of him. And he did reach back out to us, and that was when he was first in a treatment program called the Men of Nehemiah in Abilene. I'm sorry, no, Dallas, Texas.
What's he doing over there?
He went and entered a treatment
I
program.
mean, did I know about that?
No, sir, not at.
He just ambled in on his own?
Yes, sir.
Okay. Okay, when did that happen?
He went to the Men of Nehemiah.
January 26, 2023 through May 23rd, 2023.
Where was he in September, October, November, and December of 2022? According to allegation number 7 that he failed to report.
Yes, sir.
He was an absconder then.
We did lose track of him. Yes, sir. We lost contact with him.
Okay, so we're at the old Men of Nehemiah, but it says in number 8 here in 30240 that he failed to successfully complete that and left the program.
Yes, sir, he did. He initially stayed at the Men of Nehemiah. That program is a lengthy program, and he left about 7 months in. Is that right? 24 and 6 months. Came back to Jefferson County, met with him, had a case review, and then Mr. Wallace left again.
Mhm.
And then he resurfaced back in the Mena Nehemiah in Abilene, Texas. But he did not stay at that facility long.
And then what happened?
And then I lost track of him until we located him in custody.
Where was he in custody?
He was arrested in Jefferson
It's
County.
like find what, this is like, where's Waldo? The Where's Waldo day, where's Cody? How long was it we didn't know where the heck he was when we were supposed to know every moment where he was?
Your
Or
Honor,
how
there were,
long was he out of our sight?
there were different occasions for different lengths of time.
Yeah. It seemed to be kind of, we're really not supervising him anymore. He was supervising himself, which obviously is a failure. But about what, this looks like it all began, where did we fall apart here? September of 22, would it be? Maybe it was before that, because he was admitted to using meth on March 23rd of 2022.
Your Honor, and that was during the time he was actually supervised in Harris County.
I understand. I just want to know how long he's been on my watch that we really hadn't known where the heck he was. Which is not the way it's supposed to work. We says failed to report in Harris County for September, October, November, December, and January. That's September 22 through January 23. Then failed to report to the Jefferson County Probation for January of 23 and the months July and August. And
The last face-to-face contact I had with Mr. Wallace was June of 2023. Prior to his current incarceration.
okay. Pre-sentence report, anybody have one of those? Yeah. Thanks.
I'm printing a copy, Your Honor, but I also have it right here if you want to begin looking at it. I'll go grab that.
Thank you.
Your Honor, and each case does have a separate, I have a post-sentence report on one and a pre-sentence report on the other.
Okay, so we got a second degree felony on one and a state jail felony on the other. I think, make sure I didn't break it. Okay, so what are we doing on the state jail? I see 4 years is the plan on the motion to revoke probation in 30240. What's the plan in 31510?
18 months state jail, Your Honor, concurrently with.
Is that your understanding on these agreements? If I follow these agreements, sir, you have no right of appeal of your cases. Do you understand?
Yes, sir.
All right. Does the defendant waive formal readings of these motions? Can we proceed in summary and we'll take them up together?
Yes, Your Honor.
In 18-30240, and by the way, raise your hand. Do you solemnly swear or affirm any statements you make today would be the truth, the whole truth, and nothing but the truth during this hearing? So help you God. Lower your hand. In 18-30240, there's a motion to revoke probation, and as well as 31510, and we can take these up in summary.
Yes, Judge.
In summary fashion, 30240 alleges and states that on January 7th, 2019, in this court, you were placed on 10 years deferred or unadjudicated probation for robbery. Is that true? Allegation, hold that one in abeyance. In 31510, that motion to revoke unadjudicated probation in summary states that on July 8th, 2019, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of illegal possession of controlled substance. Is that true? It's true. In each of these motions to revoke probation, allegation one states you failed to report to the Jefferson County Probation Office on or about June 27th, 2023, and the months of July and August of 2023. Is that true in each case?
No, I haven't.
Number 8, you failed to successfully complete the substance abuse treatment program called the Men of Nehemiah Abilene and left that program on February 27th. I'm sorry, February 16th, 2024. Is that true? Are you pleading true? Those are true as they are alleged. You understand by plea, knowing and voluntary plea of true, one or more allegations of violations of probation, that is enough to grant motions to revoke unadjudicated probation. Can now be found guilty and sentenced up to the full range of punishment, which is up to 20 years in that robbery case and up to 2 years confinement in a felony facility in the state jail felony of 31510. Knowing that, do you insist on pleading true today? I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. All right, in each of these cases in 30240 and 31510, the motions to revoke probation, are you pleading true to allegations 1 and 8, 30240, and allegations 1 and 7 in 31510, and those motions to revoke unadjudicated probation? Are you pleading true to those allegations because they are indeed true as they are alleged regarding failing to report to the Jefferson County Probation Office and failing to complete the substance abuse treatment program as ordered? Do you understand by a voluntary and knowing plea is true? That is in each, for each violation, that is enough to grant the motions to revoke probation. Your probations can be revoked. You can now be found guilty and sentenced to the full range of punishment in each of these cases. Knowing that, you insist on pleading true today. I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true in each case. If nothing further to add, I'm going to find in each of these motions to revoke probation, you pleaded true voluntarily, knowingly, intelligently, and to 2 violations in each case of your order of probation in each case. That is enough to grant these motions to revoke unadjudicated probation by a preponderance of the evidence or greater in each case. Your deferred or unadjudicated probation in each case is now revoked. In each of these cases, you pleaded guilty voluntarily to robbery in 30240, a second-degree felony, and to illegal possession of controlled substance in 31510, a state jail felony. You entered those pleas voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty pleas in each case from State's Exhibit 1 admitted in those cases at the time of your plea to find you guilty beyond a reasonable doubt. Now that your probations are revoked, I hereby find you guilty beyond a reasonable doubt in each of these cases. In 30240, you were hereby sentenced, a robbery case. You were hereby sentenced to confinement in the institutional division of Texas Department of Criminal Justice to serve a term of 4 years. And you were ordered to pay restitution in the amount of $90 as part of those of the judgment, and that is to Matthew Vargas. In 31510, you were hereby found guilty beyond a reasonable doubt of that state jail felony. You were hereby sentenced to confinement to state jail for 18 months. These sentences shall run concurrently. Do you understand what has happened today, sir?
Yes, sir.
All right, please make sure you follow up on those restitution matters. Thank you. All right, where's your guys?
Right here.
Okay.
Ellie just bought MIS.
Oh, I know. You follow the rules, man. You know.
All right, we're back in business here. 21-38943 is called, and Stephen Pierre O'Quinn, that's
Yes,
you,
sir.
with John West, your attorney. And
Basically.
the probation office is here and the state's attorney is present. What we have before the court is a motion to revoke probation that was filed July 26, 2024. Does the defendant waive formal readings of this? Can we proceed in summary?
Yes, Your Honor.
In summary, this motion to revoke probation, and by the way, raise your right hand, sir. Do you solemnly swear or affirm any statement you make today during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer. In summary, this motion states that on October 30th, 2023, in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years. That can't be, can it? In the state jail, suspended for 10 years for the state jail felony of unauthorized use of a motor vehicle. I guess we can do that. For 10
See, I believe he was enhanced, yes, Your Honor.
I think it
enhanced.
was probably.
Yeah. I'm looking at the indictment here is we have an enhancement. You pleaded guilty to paragraph 1, the state jail felony. True to paragraphs 2 and 3, which are prior state jail felonies of theft in 2016 out of Hardin County 88th District Court. So you were found guilty of this state jail felony, but it was punished as though it were a third-degree felony punishment because you pleaded true to paragraphs 2 and 3. It's a state jail felony on the books, but it's treated as though for punishment purposes as it was a third-degree felony.
Yes, sir.
So, once again, is all of that true, sir?
Yes, sir.
You were sentenced to 10 years. Just 10 years in the state jail felony division, but it really, that's not right. That's
Yes,
gonna
sir.
be 10 years in prison, probated for 10 years, but it's a state jail felony.
Yes, sir.
But you're still looking at
10 years.
state jail felony doesn't work after 5 years. If it's not in a state jail facility, it can't go 10 years in a state jail. So because of the enhancements, it's treated as though it's a third-degree felony. So we're going to correct that then.
Oh, no objection. Yes, yes.
To
please.
what?
In the Texas Department of Criminal Justice.
Just
Institution.
imprisonment,
Yes, Your Honor.
corrected on this day to read 10 years imprisonment in the Texas Department of Criminal Justice, suspended for a supervision term of 10 years. Number 1 states you failed to report to the Jefferson County Probation Office for January 10th, March 8th, April 9th, May 9th, all 2024 in violation of your probation order. Is that true?
True or not, we're going to explain it.
Yes, sir.
Are you pleading true to that voluntarily and because it is true?
Yes.
Number 2, you failed to provide verification of performing community service hours as required. Is that true?
Yes, sir.
Number 3, you failed to pay court assessed fees as of May 9th, 2024. You are in arrears $660. Is that true?
Yes, sir.
Were you able to pay that?
It wasn't that I wasn't able to pay. It was the fact that me and my probation officer wasn't seeing eye to eye, and I wasn't gonna pay for her to put me right back into jail. Which
I don't understand that. The last sentence. I mean, if you don't pay it, it's going to go in, you're going to go to jail.
Yes, sir.
You do pay it. It's part of the order I ordered.
Yes, sir.
It's not, y'all don't negotiate. It's up to me.
Yes, sir. I
Is that
understand.
true or not?
Yes, sir. It's true.
Are you pleading true then to allegations 1, 2, and 3 voluntarily and
Yes,
because
sir.
they are true?
Yes, sir.
You understand that one or more violations of probation, pleas of truth voluntarily and knowingly and intelligently to one or more probation violations. That is enough to grant the motions to revoke probation. Your probation can be revoked and you can be sentenced to no less than 2, no more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true to these violations?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
What are we going to do?
Your Honor, the state would request that he be sentenced to the 10 years TDC. He still owes $1,000 in restitution, I believe.
You'll have to speak up.
Excuse me, it'd be $900, roughly not, or $898 in restitution that's still owed. The state would recommend the full term, Your Honor, be sentenced to penitentiary.
No, hold on. Now, these are administrative violations.
Yeah.
They're bad.
Yes, sure.
Any violation of probation is bad, but generally administrative violations don't jump up to the full range of punishment to the highest unless there's some aggravated features. That's been historical, but let me see its pre-sentence report. So we've got for misdemeanors, we've got 2 counts of theft out of Hardin County in 2012, a misdemeanor, 2 days in jail. Possession of marijuana, deferred probation in 12, revoked for 32 days in jail. And that was in Orange County. And then 22/27/18, 30 days in jail for illegal possession of marijuana in Hardin County. So adult felony, we've got in Hardin County, 2015, 2 years deferred for theft. That was revoked, sentenced to 12 months in the state jail in March of 16. Also convicted on March 16th in 12 months state jail, another Hardin County theft of property. So that's 2. Then in 2022, 18 months state jail, illegal possession of controlled substance, Orange County. And then 23, October, a year ago, you're put on probation in this case, right? So we've got 3 prior felonies. Looks like convictions
Yes, sir.
and 3 misdemeanors. 3 felonies were thefts. And so was this unauthorized use of a motor vehicle. It's theft related. And that was committed after you were convicted of 2 theft of property cases out of Hardin County. All right, okay, I see. Here we go. Okay, what do you say?
Your Honor, the big issue here is I'm not checking in because I think that all relates back to that because we had some issues and I've been informed that he had at one time had some transportation issues, some communication issues. I think they had informed that wrong telephone number. Is that
Yes, sir.
right? Okay. So if you'd like to hear from my client explain that, but that's what he's going to tell you, Your Honor. What I would suggest is doing, due to the fact that he's our administrator, he does owe some money, especially some restitution, is he's already entered his plea true to abate it for 3 months, 6 months, however the court wants to do, or 1 month, whatever, and to see if he's makes some payments, checks in. If he does, then great, let's keep him on, let him get back on track. And if he doesn't, then he's already pled true and he knows he's looking at 10 years. Because that's what the sentence is. It's 10 years, probate over 10 years. So that would be my suggestion. I think it's the best. Due to
How long
these
have
type
you
of
been in jail now?
I've been in jail going on roughly 2 months.
That's my suggestion.
All right, probation.
If you were to elect to continue on probation, I would suggest putting him under high risk caseload with the required MRT class, with 0 tolerance.
And what would you like to say, sir?
I'd like to say, if honestly, if you'll give me one more chance, I have the means to pay up what I have. I do have transportation now. My transportation is reliable, and only thing I can ask is give me one more chance to show that I
Didn't you get a chance when we put you on probation?
yes, sir.
All right.
Yes, sir.
How many freebies do you get now? It states here, you sign this. I have received a copy of this probation order. I agree to follow all conditions imposed upon me, and I know that this community supervision can be revoked for any violation. And there's your signature sworn.
Yes, sir.
Okay. So here we are, where you say, not only have I failed to conform to the orders, but I didn't tell you the truth when I said I was going to follow all the conditions.
I think he understands now. Like I said, he's been in jail for about 3 months.
How old of a man are you, sir?
Sir,
How old of a man are you?
I'm 32.
He's been an adult for 17 years.
I
So he
understand.
knows how to play the adult game, which is live honestly, don't harm anybody, give each person respect, period.
Yes, sir.
You're not showing that.
I think my biggest argument is this is not new offenses. This is not something like that. This is purely administrative issues. And I think if we give him some time.
All right, here's what we're gonna do. I'm going to find that there is sufficient evidence supporting this motion to grant it by preponderance of the evidence or greater as allegations 1 and 2 and 3 have been proven true by your voluntary and knowingly plea of true to those which are enough to grant this motion to revoke probation and sentence you to 10 years in prison. But what I'm going to do is hold this in abeyance. You're going to have to do 30 more days in this county jail. Because everything has a price when you fail. After you've made promises not to fail. You are ordered to complete, in all of these terms and probation, fulfill them completely. You have restitution
Yes, sir.
that has to be paid. Do you work somewhere when you're not in jail?
No, sir, but I do
Do you have a trade?
Yes, sir.
What?
I am a carpenter by trade.
Well, carpenter jobs all over. They need some help. What are you lollygagging about that for?
Just hard times right now. I do.
Oh, you gotta, how about the willing, I know you're in jail. How about the willingness to do it? Because I
Yes.
think people are carpenter jobs, as long as you're good at it. They're gonna help, they're gonna want you to stay out of jail because they need good help if you're good.
Yes, sir.
All right, those are the orders of the court. Follow all those terms and conditions of probation, 30 additional days. And we're gonna review this in 90 days to see how you're doing. Okay.
Yes, sir.
Judge, are you going to add those other recommended conditions from probation?
Uh,
The high, medium risk case load and MRT?
yes. Yes.
Thank you, ma'am.
Here, thank you.
He's got to sign. some-
There, he's gotta sign this.
You gotta sign All right.
Thanks. David, you've got Cody Francois. What are we gonna do with Cody?
He had 6 cases.
He's got 6 cases.
I followed on it, notice, bro. I'm working on them. He would like to.
Hold on. He's-
the notice, right?
He says now, Mr. Kimler says he's representing. How long have you been representing?
Whenever was he from?
Oh, come on. Yeah, why is he confused and why am I confused?
Because the e-filing system didn't.
You don't blame it on the system. How about communicating with everybody? Did you-
I spoke with him on Saturday, Judge.
With
He
whom?
indicated he wanted to hire Mr. Kimmer. Apparently he had, but I spoke.
When did he hire you?
Whatever that says. What does that say?
Called it on the 25th of this month, Judge, which was after we had prepped this docket.
Okay, did you know them?
No, sir, I didn't know that.
You gotta tell him so that he can back
It
off.
should be on.
That was filed 4 days
It should be
ago.
on the online.
That was, how about professional courtesy of just sending a tip to him so that he knows? I mean, he may have worked over the weekend since the 26th. This thing's been done 4 days ago.
Mhm.
And now
I'll see
how do
the
you
bill
give him
file.
back his time that he spent?
Judge,
You know what? That's what I expect everybody, just professional courtesy to inform the other people, period.
e-file, then it's on the.
I don't care. You just tell a fellow professional, hey, I'm now substituting for you, so you don't have to spend the weekend working at the jail. Don't you think that's just professional courtesy?
It's not a motion. to
It's-
substitute.
you know, it's-
Notice of rep, and I don't see anything unprofessional. about you
I do.
having a Notice of rep.
I think it's poor way to deal with something. How do you give him back his time when you've substituted in and he's not aware of it?
Then it should be on the online system. There should be we're on the electronic system, then it should be done through e-filing. There should be an e-file generated to him.
I expect,
Once that's
I
filed,
ex-
then it should be.
I've done
e-filed.
this a lot longer than you, and that professional courtesy has always been the same. You tip your fellow professional off so that they don't spend their time up in the jail, not aware that you have substituted in. That's only decent. Everybody
I
knows
didn't
that.
substitute in. I didn't follow.
It's not a debate, sir. That's what I expect.
So I'm required to notify.
I expect you to, professional courtesy is what I expect from fellow professionals, and that wasn't given when you did this. You knew he was being represented by David or
I
somebody.
didn't know he was representing. Mr. Grove. I didn't.
How long have you been representing?
several months, Judge.
I didn't check it.
But when
Would
I
you ought
talked,
to check?
when I talked to him, the defendant, he didn't even say he was represented by Mr. Kimball.
They came in and hired me.
Well, again, though, I mean.
I know it's not fair to him,
It's,
and everybody knows that. That's not right. Oh, these are motions to revoke probation.
Correct.
One's regular probation on Dwaylen Hambrick. Let's deal with that one first.
not sure.
Like I said.
We need Dwaylen Hambrick.
Good, well, you're so.
All right. There's 236084, a motion to revoke probation. In that case, in 24 CR 1097, a new indictment as of May 15th for aggravated assault with a deadly weapon. And it looks like he is a habitual felon because 2 prior convictions are alleged. So he's looking at 25 to life. 25 years imprisonment up to life imprisonment. In that case, there's a motion to revoke probation in 36084 where he is alleged to have been sentenced to 10 years in prison, probated for 10 years out of this court, February 15th, 2022. And I have the pre-sentence report in 20-36084, the motion to revoke probation case, where it shows the defendant was convicted out as alleged in the indictments, in the indictment allegations in paragraphs 2 and 3 and 1097 of the second degree felony of robbery, where he was placed on 10 years deferred or unadjudicated probation, and that was revoked, and he was sentenced to 4 years in prison, 2022. Then the evading arrest or detention is the case where he was convicted. That is represented in 36084, the motion to revoke probation pending before this court. He was sentenced to 10 years in prison for that. And then that was suspended. He was placed on regular probation. Now the indictment here in 1097 alleges that on or about April 7th of this year in Jefferson County, Texas, the defendant committed the second degree felony of aggravated assault with a deadly weapon, namely a firearm. And I guess they had a familial relationship or dating relationship.
Yes, sir. For some reason, back in September, I noted that this new offense will possibly be dismissed. I'm trying to remember why.
Well, wouldn't be the first time in a dating relationship assault case where somebody's indicted and then it's dismissed.
I think she came by.
Mhm. Why, what's your motion?
We wanted the bond, said, yeah.
And state?
Judge, I think is on the probation. Is he on deferred?
Straight.
No, it's
He's on straight.
He's alleged that aggravated assault, number 2, is failing to provide verification performing community service hours and
Yeah.
failing to pay fees. So there's two, one substantive and then 2 administrative. What's on the community service hours? How much?
He has 577 hours left of the 600 he did.
So you did 23 hours?
Yes, in 2022.
It is my handwriting that says the new charge will be dismissed, so I don't have any objections to you setting the bond. I want to double check and make sure that new charge being dismissed, other allegations can be led to or dealt with without the MTRP. Is what I put on my notes. So I'll double check, but I think I'm going to dismiss that new charge. I've got to figure out why I didn't do that already.
It says in the probable cause. Punched, the complaint says he punched her in the mouth, choking her. Pulled out a gun, threatened her with it, pointed it at her, told her to leave or he was going to beat her and kill her. She was in fear of her life, called the police.
Yeah, I have a request from the complainant witness to dismiss that. On September 5th of 24, I put dismiss. I don't know if I. You show dismissal on that yet already? If not, I'll
I've
take care.
got my tablet.
Okay, I'll take care of it now.
Okay, so
So on the new one, he can. Judge, we can decide whether to
you have
complete
to have a
with the other
motion. If you're
allegations.
gonna
Yes.
dismiss it, there's just the motion
Yes,
to
sir.
revoke probation with the administrative violation.
Yes, sir. I don't have a problem with you setting the bond. Can't do anything about anything else.
The state of abating count one in MTLP.
What's the motion to revoke probation bond? Is there any?
There's no bond present.
There's no bond.
$10,000.
All right, Dwayne. Thank you.
I'll get rid of the new case.
Look, that's that's a terrible set of allegations.
Outstanding.
And the police went out and they saw somebody who was injured. Unless she kept falling on her face intentionally, then we all know what happened. Right?
Outstanding.
That's rhetorical. It's just. You don't. That's no, first of all, there's no way to treat any human being, especially someone you're supposed to have a romantic relationship with. Is that the way you show affection? You must be greater at Christmas time. That's just pathetic. But you've got prior convictions of assaultive behavior. You don't have any room to have any assaults. You got a problem, obviously, of self-control, but you don't beat up on girls. That's not manly anyway. That's all. All right, 21-38757. This is Chelsea Newton, and there's a motion to revoke probation on this one. What are we gonna do?
We're requesting a bond. She hasn't been misdemeanor.
Do you happen to have the pre-sentence report on this one, please? Chelsea Newton, thank you very much. Make sure I don't lose this.
Yeah.
Okay, so. There you are. Got caught stealing here at the Walmart. $116. So we have a Class B deferred in 12. Class B theft. Regular probation in 14. Class B theft in 17, 2 days in jail. So those are. It's like misdemeanor convictions here. Then aggravated assault in 2016. 1 year deferred. Well, that went by in a week of an eye. Then this theft here. And Yes, where? Just not just a theft. Okay. It's made a felony because of the prior theft convictions that we discussed in 2014 and 2017. This motion alleges that the defendant committed the offense of assault on or about February 18th, 2024. Do you have any information on that from Spain? Yes.
I have a DCF didn't have. You want to see?
Did? I don't have it. I have your memo, but that has somewhere.
Oh, yes, I don't know.
No, not the,
No, it's in there. It's underneath that. Sorry.
there you go. I'm gonna give you back, so. What are you doing at the Humidor Lounge at 1:30 in the morning when you're on my watch from probation, when you're supposed to be at home? What's wrong with you on that? You know better. You're at a bar while you're on this court supervision at 1:30 in the morning?
She's alleged to have been.
Mm-hmm.
She's on video, Your Honor. They have her on.
He's allegedly on the
She's
video,
allegedly
huh?
on the
Is that a?
May not be her. I don't know.
It's probably a superimposed likeness, just like her, that was brought from the planet Venus.
There's been no proof. We're just asking for a bond.
Well, circumstances of the underlying adventure are part of it all. Yeah, I can trust you. I don't think. There's a probation order that says you're supposed to be in by 10.
She was identified by several individuals there, as well as an officer that knew her as well.
Well, again, I don't have the opportunity to prosecute. This is alleged, that's the allegation.
We can reset it and I'll have all those officers show up.
We smart bonds. He's on the firm.
$75,000 bond. You have to follow the terms. I mean, there's an assault here that's been alleged, which is a crime. Then you at 1:30 at a bar, having a good time. When you're supposed to. You have children too, don't you? Are you taking care of how many children? 5 children? Unless they were at the bar with you.
They weren't. Well, it's alleged that they were actually in the car.
They were in the car asleep while she's in the bar.
Alleged.
She told me that.
The defendant told you that.
Yes.
$75,000. What's being done about the children and neglect?
I'm not sure.
We don't know.
I do know one of her,
That's terrible.
little boys is supposed to be having eye surgery and he wasn't able to have it because she's in jail. So.
All right, this motion to revoke. When can you be ready? 3 weeks?
Today.
3
I
weeks?
the sooner the better, because she's probably.
3 weeks.
They put the bonds.
Set for 3 weeks.
See if you can make.
We're gonna set it for a hearing nonetheless.